What's up, you guys? Welcome to Unit 4 of the Modern Real Estate Practice in Illinois Real Estate Agency. Let's start. Overview. The term agency is used to describe that special relationship. Agency is governed by two kinds of laws: statutory law, the law, rules, and regulation enacted by legislators and other governing bodies, and common law, the rules of a society established by court decision. Law of agency definition. Agency refers to a strict defined legal relationship. The agent owes the client or principal a duty of loyalty. This duty of loyalty rises above any personal interest of the agent. The relationship of the broker, managing broker, or residential leasing agent with the sponsoring broker is also called a general agency because they represent the sponsoring broker in all daily actions. Contracts most effectively establish the agent-client relationship. Agency relationships in Illinois are governed under statutory law. The body of law on which Illinois agency is based is Article 15 of the Real Estate License Act of 2000 and may serve as a basis for private rights of actions and defenses by sellers, buyers, landlords, tenants, managing brokers, and brokers. The law of agency defines the rights and duties of the principals and the agent. Both contract law and real estate licensing laws, in addition to the law of agency, interpret the relationship between real estate licensees and their clients. In Illinois, the Real Estate License Act of 2000 is given precedence in defining legal real estate agency concepts. Insofar as real estate is considered, Illinois is a statutory agency state that has replaced common law duties with statutory duties. In Illinois, a licensee is presumed to have an agency relationship with the principal unless there is a statement in writing articulating a different relationship. Statutory definitions. Agency means a relationship in which a real estate broker or licensee, whether directly or through an affiliated licensee, represents a consumer by the consumer's consent, whether expressed or implied, in a real property transaction. An agent is the individual who is authorized and consents to represent the interest of another person. In the real estate business, a firm sponsoring broker is the agent and shares this responsibility with the licensees who work for him. A brokerage agreement is an agreement written or oral between a sponsoring broker and a consumer for licensed activities to be provided to a consumer in return for compensation or the right to receive compensation from another. In Illinois, any exclusive brokerage agreement must be in writing. A consumer means a person or entity seeking or receiving licensed activity. A client means a person who is being represented by a licensee. A customer means a consumer who is not being represented by the licensee. Compensation means the valuable consideration given by one person or entity to another person or entity in exchange for the performance of some activity or service. Confidential information means information obtained by a licensee during the term of a brokerage agreement that was made confidential by the written request or written instruction of the client, deals with the negotiation position of the client, or is information the disclosure of which could materially harm the negotiation position of the client. This information must not be shared unless the client gives authorization by word or conduct for the licensee to share the information. The disclosure is required by law, or the information becomes public from a source other than the licensee. The client is the principal to whom the agent gives advice and counsel. The agent is entrusted with certain confidential information and has fiduciary responsibilities called statutory responsibilities in Illinois to the principal. An agent works for the client and the customer. The customer is entitled to factual information and honest dealing as a consumer, but never receives advice and counsel or confidential information about the principal. The real estate licensee works for the client, but cooperates with the customer. Just as the agent owes certain duties to the principal has responsibilities toward the agent. The principal's primary duties are to comply with the brokerage agreement and cooperate with the agent. The principal must not hinder the agent and must deal with the agent in good faith. The principal also must compensate the agent according to the terms of the brokerage agreement. Fiduciary statutory responsibilities. The agency agreement usually authorizes the real estate licensee to act for the principal. As such, the real estate licensee owes the principal certain fiduciary duties. A fiduciary is one who is placed in a position of trust and confidence. These duties include the duty of care, obedience, loyalty, disclosure, accounting, and confidentiality. The obligations are summarized. Memory tip. The 6 common law fiduciary duties may be remembered by the acronym CODE AC. Care, obedience, loyalty, disclosure, accounting, confidentiality. The duty of care. Agents must exercise a reasonable degree of care while transacting the business entrusted to them by the principal. The duty of obedience. The fiduciary relationship obligates the agent to act in good faith at all times, obeying the principal's instructions in accordance with the contract. However, the obedience is not absolute. The agent may not obey instructions that are unlawful or unethical. The duty of loyalty. The principal's interest comes first, even above the self-interest of the agent. Illinois license law prohibits a licensee to serve as a dual agent in any transaction to which he or she or an entity in which he or she has ownership interest is a party to the transaction. The agent must be particularly sensitive to any possible conflict of interest. The duty of disclosure. It is the agent's duty to keep the principal informed of all facts or information that could affect the transaction. Disclosure forms are usually completed by the seller before he signs the listing agreement or at the time of signing. An agent for a buyer must disclose the efficiency of a property as well. The Illinois Association of Realtors Residential Real Property Disclosure Report shifts the responsibility for full disclosure from the real estate agent to the seller. It requires the seller of 1 to 4 unit residential properties fill out property disclosure forms revealing any material defects they are aware of in the real estate for the sale. The completed forms are given to the buyer before an offer is made. If the disclosure form is delivered after the offer has been accepted, and if it has any negative disclosure, the buyer has 3 business days to cancel the contract. If the seller learns of a new problem after a contract has been signed, and up until closing, disclosure must be made in writing to the buyer. In the later case, the buyer does not have the power to simply cancel the contract. Compensation may be negotiated or the problem remedied by the seller. Under no circumstances should a real estate licensee help the seller complete this form, either physically or by answering any questions. The duty of accounting. Most state license laws require that agents periodically report the status of all funds or property received from or on behalf of the principal. Similarly, most state license laws require that licensees give accurate copies of all documents to all affected parties and keep copies on file for a period of time. Illinois licensees are required to deliver true copies of all executed or initialed documents to the people who signed or initialed them within 24 hours. In Illinois, all funds entrusted to a licensee must be deposited in a special escrow account by the next business day following the signing of a sales contract or lease, unless the contract terms specify a different time frame. Commingling such monies with the licensee's personal or general business funds is illegal. Conversion, the practice of using those escrow accounts as the licensee's own money, is illegal as well. Licensees should be aware that records of escrow accounts transactions and reconciliations must be kept on file for at least 5 years. The duty of confidentiality. Confidentiality is a key element of fiduciary duties. Client information obtained during the term of the brokerage agreement must be kept confidential. Although an agent may not disclose personal confidential information about her principal, non-material facts about the property, physical condition, or its environment must always be disclosed. A material fact is any fact that, if known, might reasonably be expected to affect the course of events. Opinion versus fact. Statement of fact must be accurate. Generalized, vague exaggeration of a property's benefits is called puffing. While puffing is not illegal, licensees must ensure that none of their statements can be interpreted as fraudulent. Fraud is the intentional misrepresentation of a material fact so as to harm or take advantage of another person. That includes not only making false statements about a property, but also intentionally concealing or failing to disclose important facts. The misrepresentation or omission does not have to be intentional to result in licensee liability. Negligent misrepresentation occurs when the licensee should have known that a statement made about a material fact was false. If the consumer relies on the licensee's statements, the licensee is liable for any damage that results. The Illinois Real Estate License Act clearly states that a licensee should not be liable to a client for providing false information to the client if the false information was provided to the licensee by a customer, unless the licensee knew or should have known for the information was false. It also states that licensee should not be liable to a customer for providing false information to the customer if the false information was provided to the licensee by the licensee's client and the licensee did not have actual knowledge that information was false. In addition, the Act states that licensees shall treat all customers honestly and shall not negligently or knowingly give them false information. Latent defects. A structural defect that would not normally be uncovered over the course of an ordinary inspection due to the placement or type of defect is called a latent defect. The seller has a duty to disclose any known latent defects that threaten structural soundness of personal safety. Buyers have been able to either resign the sales contract or receive monetary damages when a seller fails to reveal known latent defects. The court also has decided in the favor of the buyer when the seller neglects to reveal violation of zoning or building codes. It is the licensee's duties to disclose any material facts that may affect the property's value or desirability, whether or not they are known to or disclosed by the seller. Stigmatized properties. Stigmatized properties are those properties that society has branded undesirable because of the event that occurred there. Because of the potential liability to a licensee for inadequately researching and disclosing material facts concerning a property's condition, the licensee should seek legal counsel when dealing with a stigmatized property. In Illinois, licensees have no legal duty to disclose that a property is stigmatized. Megan's Law. Megan's Law is a general name for state and federal laws requiring law enforcement authorities to make information available to the general public regarding registered sex offenders. Listing agents have no legal duty to disclose that a registered sex offender lives near a listed home. Buyer's agents should refer their buyer clients to publicly available sex offender location lists if asked. Article 15 of the Real Estate License Act of 2000 states that no cause of action shall arise against the licensee for the failure to disclose a fact situation on property that is not the subject of the transaction, and no cause of action shall arise against the licensee for the failure to disclose physical conditions located on property that is not the subject of the transaction, that do not have a substantial adverse effect on the value of the real estate that is the subject of the transaction. Article 15 of the Real Estate License Act further explains that in dealing with specific situations related to disclosure, no cause of action shall arise against a licensee for the failure to disclose that an occupant of that property was inflicted with HIV or any other medical condition, or that the property was the site of an act or occurred which had no effect on the physical condition of the property or its environmental or the structures located thereon. Any action brought under Article 15 must commence within 2 years after the person brings the action knew or should have known of such action or omission. In no event can the action be brought more than 5 years after the date on which the act or omission occurred. Customer level service. An agent owes a customer the duties of reasonable care and skill, honesty and fair dealing, and disclosure of known facts. However, Illinois license laws does not forth the duties that licensees owe to a third party. Customer, buyer or seller. Licensees are to treat all customers honestly. They cannot negligently or knowingly give customers false information. Licensees must disclose all adverse material facts about the physical condition of the property to the customer that are actually known by the licensee and that cannot be discovered by a reasonably diligent inspection of the property by the customer. In Illinois, a licensee may be held liable to a seller or buyer if the licensee misrepresents material facts about a property, and if the seller or the buyer suffers monetary loss through reliance on these statements. Licensees who attempt to avoid liability to buyers through the use of a waiver or an exculpatory clause in the sales contract would probably be unsuccessful. Illinois courts have ruled that a contract cannot eliminate the rights given to a consumer via the law. Creation and termination of agency. Creation of agency. An agency relationship may be based on a formal agreement between the parties, express agency, or it may result from the parties' behavior, implied agency. Express agency. Express agency. The principal and agent may enter into an express contract, also called an express agreement, in which the parties formally express their intention to establish an agency relationship and states terms and conditions. The agreement may be either oral or written. An agency relationship between a seller and a sponsoring broker is generally created by a written employment contract, commonly called a listing agreement, in which authorizes the sponsoring broker or designated licensee to find a buyer or tenant for the owner's property. An express agency relationship between a buyer and a sponsored broker is created by a buyer agency agreement. Implied agency. An agency also may be created by implied contract. This occurs when the actions of the licensee indicate that the licensee has formed an agency relationship with the party. Even though the licensee may not have consciously planned to create an agency relationship, the parties can create one unintentionally, inadvertently, or accidentally by their actions. Licensees should be considered to be representing the consumer they are working with as a designated agent for the consumer unless there is a written agreement between the consumer and the sponsoring broker stating otherwise. Agency disclosure is crucial to the consumer's understanding of the relationship to the licensee. Compensation. The source of compensation does not determine agency. A real estate agent does not necessarily represent the person who pays her commission. In fact, agency can exist even if no fee is involved. It is called a gratitude agency. In Illinois, compensation does not determine the agency relationship. Both the buyers and the seller's real estate agents are often paid by the seller in a cooperative commission arrangement. Termination of agency. Licensees are not allowed to obtain a written brokerage agreement that does not expire automatically within a certain period of time, or provide the client the right to terminate the agreement annually by giving no more than 30 days advance written notice. In agency coupled with an interest, the agent has an interest in the subject of the agency, such as the property being sold. An agency coupled with an interest cannot be revoked by the principal or be terminated on the principal's death. Types of agency relationships. Limitations on agency authority. A universal agent is a person empowered to do anything that the principal could do personally. The universal agent's authority to act on behalf of the principal is virtually unlimited. In Illinois, a written power of attorney is required to create a universal agency. A general agent may represent the principal in a broad range of matters related to parties' business or activities, like the property manager. A, a special agent is authorized to represent the principal in one specific act or business transaction only, under detailed instructions. A special power of attorney is another legal means of authorizing an agent to carry out only a specific act or acts. A designated agent is a person authorized by the sponsoring broker to act as the agent of a specific principal. A designated agent is the only licensee in the company who has a fiduciary responsibility toward that principal. Designated agency is recognized in Illinois. A licensee shall advise a consumer in writing before acting as their designated agent that a designated agency relationship exists and disclose the name or names of the consumer's designated agent. Single agency. When an agent or firm represents only one party exclusively in a real estate transaction, this relationship is called single agency. The agent and firm's fiduciary and statutory duties are provided only to that one party. Buyer agency. A buyer agency relationship is established in the same way as any other agency relationship, by contract, agreement, or implication. The buyer agency may receive a fee from the buyer or share in the seller paid commission to the listing sponsoring broker or both, depending on the terms of the agency agreement. In Illinois, though not required by law, it is common for the listing sponsoring broker to share the listing commission with the buyer's sponsoring brokerage. Property management agency. An owner may employ a sponsoring broker to market, lease, maintain, or manage the owner's property. Such an arrangement is called property management. The sponsoring broker has a fiduciary responsibility to the client owner. Dual agency. In dual agency, the agent represents two principals in the same transaction. Dual agency requires equal loyalty to two separate principals at the same time. Disclosed dual agency. Real estate licensing laws permit dual agency only if the buyer and the seller are informed and consent to the licensee's representation of both in the same transaction. Confirmation of consent to dual agency. In Illinois, all parties must give consent and confirmation to the arrangement in writing. Dual agency consent. Dual agency is when one licensee represents the interests of both buyer and seller or lessor and lessee in a transaction. In Illinois, dual agency is legal as long as all parties give their consent and confirmation in writing. The licensee must receive the written consent before acting as a dual agent for the parties. Designated agency describes a business model where licensees in an office may represent both buyers and sellers. Under designated agency, the sponsoring broker designates one agent to represent the seller and one agent to represent the buyer. Designated agency is legal in Illinois and constitutes a business model that is commonly chosen and described in a real estate company's written policy. License law requires that the licensee to disclose that a designated agency relationship exists and to put in writing the name of the designated agent. Disclosure of agency. Real estate licensees are required to disclose the parties they represent. Licensees are considered to be representing the consumer they are working with as the consumer's designated agent, unless there is a written agreement between the sponsoring broker and the consumer providing that there is a different relationship. Article 15, Section 1535 of the Real Estate License Act of 2000 discusses agency relationship disclosure. The name or name, this must occur no later than beginning to work as a designated agent on behalf of the consumer. The name or names of the designated agent or agents must be in writing, and the sponsoring broker's compensation and policy regarding cooperating and sponsoring brokers who represent other parties in a transaction must be disclosed. A licensee must also disclose in writing to a customer that the licensee is not acting as the agent of the customer at the time intended to prevent disclosure of confidential information from a customer to a licensee, but in no event later than the preparation of an offer to purchase or lease real property. This is known as the disclosure of no agency and is required at first substantive contract. Substantive contract is when the dialogue between a licensee and consumer moves from casual conversation to the consumer's motives, objectives, financial qualifications, and other confidential information that, if disclosed, could harm the consumer's bargain position. Summary. The common law of agency has historically governed the principal-agent relationship. Agency relationships may be expressed either by the words of the parties or by written agreement, or they may be implied by the parties' actions. In single agency relationship, the licensee or agent represents one party, either the buyer or the seller in that transaction. In some states, if the agent elicits the assistance of other licensees who cooperate in the transaction, the other licensee may become subagents of the principal. Any blanket offering of subagency by a multiple listing service in Illinois is illegal. Many states, including Illinois, are dominated by non-single agency firms. These firms work with both buyers and sellers, including buyer and sellers in the same transaction. They will consider dual agency in the event it develops, or will assign designated agents to each of the two parties, usually a seller and a buyer. Many states, including Illinois, have adopted statutes that replace the common law of agency and amplifies it. Representing two opposite parties in the same transaction constitutes dual agency. Licensees must be careful not to create dual agency when none was intended. This unintentional or inadvertent dual agency can result in the sales contract being rescinded and the commission being forfeited or in a lawsuit. Disclosed dual agency requires that both principals give consent to and confirmation of in writing to the licensee's multiple representation. In any case, the prospective parties in any transaction should be informed about agency alternatives and the way in which client level versus customer level service differs. Many states, including Illinois, have mandatory agency disclosure laws. The source of compensation for the client services does not determine whether party it represents. Licensees have certain duties and obligations to their customers as well. Consumers are entitled to fair and honest dealings and to the information necessary for them to make informed decisions. This includes accurate information about the property. Some states, including Illinois, have mandatory property disclosure laws. Real estate license laws and regulations govern the professional conduct of managing brokers, and residential leasing agents. The license laws are enacted to protect the public by ensuring a standard of competence and professionalism in the real estate industry. Stigmatized properties are those properties that society has branded undesirable because of events that occurred there. Stigma is the continued negative association with or feeling about the property. Article 15 of the Real Estate License Act of 2000, as amended in 2020, supersedes any previous agency law. Illinois agency law currently presumes that a broker or managing broker who is working with the seller represents the seller-client relationship. A licensee working with a buyer is presumed to represent the buyer. However, before a customer discloses confidential information, the licensee shall provide them with a written disclosure of no agency. Before a licensee can act as a designated agent, the consumer shall receive a written disclosure of designated agency. An express written agreement with either seller or buyer is most protective of everyone's interest. The Real Estate License Act of 2000, along with the rules governing permitted dual agency, stipulates that consent and confirmation of dual agency must be obtained in writing to be legal. Merely designating one licensee to represent sellers and another to represent buyers does not by itself constitute dual agency. Licensees operate as designated agents most of the time. Agency relationship disclosure requires written notice to the consumer of the name or names of the designated agent, that a designated agency relationship exists unless there is a written agreement providing otherwise, and the sponsor broker's compensation and policy regarding compensation cooperation with other sponsoring brokers. Dual agency, however, occurs if the same agent represents both parties in a transaction. Then additional designated agents sometimes need to be made so that so that two licensees are involved, each representing only one party, unless a disclosed dual agency is agreed to in writing. And that is it for Unit 4. I hope you guys enjoyed the video, and sorry for the background noise and for a bit of studying, but I hope you guys passed the real estate test, and let's go to chapter 5. And God loves you guys.